Hello friends, welcome once again. Let us continue our discussion on the Champakam Dorairajan case. In the previous video, we have looked at the facts and the lead up to the Supreme Court decision, which included the judgment given by the High Court at Madras. The Madras High Court had issued a writ in favor of Mrs. Champakam Dorairajan and Mr. Srinivasan, a writ of mandamus issued against all the state authorities of Madras that were preventing these two candidates from uh, applying for their uh, their desired courses of education, medicine and engineering respectively, and the state of Madras then appealed the issue of that writ, and that is how the case came before the Supreme Court. We had a 7-judge bench this time. This was the largest bench till that time, um, at least largest for our cases, definitely led by Chief Justice Hiralal J. Kisandas Kania, and then Justices Sudhiranjan Das, Syed Fazil Ali, Patanjali Shastri, Meherchand Mahajan, Vivian Bose, and B.K. Mukherjee. The judgment for this case was written on behalf of all 7 by Justice Sudhiranjan Das, the second name in that particular list. That is right, it was a unanimous judgment, 7-0, spoiler alert. But now that we've looked at the bench, let's look at the bar that was represented here. Mr. V.K.T. Chari, the Advocate General of the State of Madras, representing the appellant, Madras State, and the respondents really got it right when they scored the appointment of Mr. Alladi Krishnaswamy Iyer. Now, Mr. Iyer is a very well known luminary in our freedom struggle as well as beyond. He was, of course, most importantly, a member of the Constituent Assembly. He served on 9 different committees on the Constituent Assembly of India, including the drafting committee. So, having someone who actually wrote the articles under discussion arguing for you was a major coup, was a major victory already for the respondents, for Champakam Dorairajan and C.R. Srinivasan. And one might say that must have surely made a significant difference to the outcome of the case. So those were the counsel, and now we quickly move on to the arguments. There's just one real major argument being made here. It all came down to Article 29, Clause 2, which we have looked at in the previous video, which we will look at once again. And this particular article 29.2 was what the state of Madras was arguing against. Article 29.2 states that no citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of state funds on grounds only of religion, race, caste, language, or any of them. The argument made by the state of Madras was that Article 29 is also governed or should also be read with other articles of the Constitution, specifically Article 46. Article 46 lies in Part 4 of the Constitution, the part that is entitled the Directive Principles of State Policy, and Article 46 states that the state shall promote with special care the educational and economic interests of the weaker sections of the people, and in particular of the scheduled castes and the scheduled tribes, and shall protect them from social injustice and all forms of exploitation. So the argument made by the state of Madras was that Article 46 governs Article 29 as well. Part 4 should override Part 3. That is, directive principles of state policy are more important and shall override the fundamental rights of the people of India. That was the argument made by the state of Madras, by the appellant in this particular case. At this juncture, they have, of course, appealed to the Supreme Court. The respondents, Champakam Dorairajan and C.R. Srinivasan, the argument made on their behalf was that the Constitution itself states that Article 46, which is a part of Part 4, cannot override Part 3, the fundamental rights, as is given by Article 37, another article in Part 4. Article 37 states that the provisions contained in this part, in Part 4, shall not be enforceable by any court. That really is all that Mr. Alladi Krishnaswamy Iyer had to argue before the court. He, of course, was a member of the drafting committee of the Constituent Assembly of India, and his argument obviously carried weight. He said that when, basically he didn't use those words, but he indicated that when we wrote Part 4, we wanted to ensure that Part 4 was not superior to Part 3. The provisions contained in Part 4 cannot be enforced by any court, including the Supreme Court. It is just an enlisting of the principles laid down, which are nevertheless fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. It does not mean that once those principles are applied, those laws shall override the fundamental rights. That is not what it means. That was the argument made by Mr. Alladi Krishnaswamy Iyer on behalf of Champakam Dorairajan. There is another article which comes into the discussion, and that is Article 16. There shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state, and no citizen shall, on grounds only of religion, race, caste, sex, descent, place of birth, residence, or any of them, be ineligible for or discriminated against in respect or any employment or office under the state. What is the purpose of this article? Why is it in discussion? Quite clearly, it has nothing to do with admission to medical or engineering college. But this article comes into the picture because of clause 4. We have read clause 1 and 2. Clause 4 of the article states that nothing in this article shall prevent the state from making any provision for the reservation or of appointments of posts in favor of any backward class of citizens which in the opinion of the state is not adequately represented in the services under the state. This is a crucial exception present only in Article 16, or present only in Article 16 at the time of the Champakam Dorairajan case. Later on, of course, the constitution was amended to include exactly this kind of an exception in Article 15 as well. But at this moment, the argument could be made, and was indeed made, on behalf of Champakam Dorairajan, that just like there was an exception to Article 16, if the Constituent Assembly desired to make reservations in admissions to state-aided institutions, educational institutions, then such an exception would have been present under Article 29 as well. It, however, did not exist. It existed only in Article 16, which dealt with appointments to posts under the government of India or under the state governments. Therefore, Article 16 clause 4 would have been wholly unnecessary and redundant if the argument was that Article 46 overrode fundamental rights. A very logical argument, isn't it? What is being argued here is that if Article 46, which is a directive principle, is supposed to override all the fundamental rights, then why would this exception be present at all? Why would Article 16 need to state that nothing shall prevent the state from making reservations, etc., if anyway that provision was present in Article 47? This exception needed to be made because Article 46 could not override fundamental rights on its own. It needed this kind of an enabling provision. Such an enabling provision existed in Article 16 but not Article 29, and Article 29 is the one which deals with admission to government aided educational institutions, one of which was applied to by Mr. Srinivasan and not applied to by Ms. Dorairajan. And that brings us to the next point. What were the arguments that were not made before the Supreme Court? We are indebted to Mr. Chintan Chandrachud's book, The Cases That India Forgot. That particular book mentions this situation quite clearly. Where was Mrs. Dorairajan's locus standi? How could she apply for a writ of mandamus asking the state of Madras to ignore its communal GO when she herself had not applied for admission, when she herself had not suffered the violation of her right to equality. Mrs. Champakam Dorairajan, that is right, had not actually been denied admission because she hadn't actually applied for admission to a government college of medicine in the state of Madras. This petition that she had brought before the Madras High Court originally was only after inquiring and finding that her marks as a Brahman were not enough, that there were only 2 seats per 14 for Brahmins, and there were there were candidates from her community who had secured more marks than her. There were candidates from outside her community who had scored fewer marks but still would get admitted, and that information was sufficient for her, according to her, to petition the higher judiciary. Mr. Srinivasan, on the other hand, had applied for admission to the engineering college in Guindy, had been denied admission despite having better marks than many other people who were admitted. So he definitely had a standing, he definitely had the locus standi. Mrs. Dorairajan actually had not. So it can be argued that the court should have then thrown out the case it's there itself, at least Champakam Dorairajan's case, if not Srinivasan's petition. But as it happened, the court simply expressed its unease that this is how it has been, but we are anyway going to go ahead and rule on the matter because this was not argued or commented upon by the Madras High Court either. And anyway, Mr. Srinivasan's case, which had been clubbed along with Mrs. Dorairajan's case, was anyway not going to suffer because of this locus standi argument. So Chintan Chandrachud in his book has mentioned that this was perhaps a precursor to the public interest litigations that have proliferated in our jurisprudence later on over the next few decades, much after this. So this was a proto-PIL almost, where the petitioner is not actually affected by anything, any particular government policy, etc., but is representing some amorphous group of people, and in this case her community, the Brahmins of the state of Madras. Another argument that was not made was the title of Article 29. Article 29, when we look at the Constitution, talks about the protection of interests of minorities. That is the name of the article under which Clause 2 was relied upon by Champakam Dorairajan. No citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of state funds on grounds only of religion, race, caste, language, or any of them. That is quite fine, quite clear. But all of it comes under an article entitled Protection of Interests of Minorities. And there was no question of anyone being a minority over here, or anyone being protected on account of being a minority or discriminated against on account of being a minority. But that argument was not made either, and therefore the court did not go into it. Interestingly, we should mention this because when eventually this judgment led to the passage of the First Amendment, and the exception that existed in Article 16 was also added to the Constitution with regards to admissions to educational institutions, it was not added in this article. It was not added in Article 29, but instead it was added further up in the very interesting, crucial Article 15. Well, let me just remind you of what Article 15 is. Discrimination on the grounds of religion, caste, sex, etc. Nothing in this article shall prevent the state from making any special provision for the advancement of weaker sections. Any special relate to their admission to educational institutions, including private educational institutions. This was added by the First Amendment, not to Article 29, which was the basis of the Champakam Dorairajan judgment, but to Article 15, which just shows once again that perhaps this argument, that the title of Article 29 was Protection of Interests of Minorities, perhaps this would have been a reasonably strong argument by the state of Madras, but it was never made. The judgment came out in favor of the respondent. The appeal was dismissed with cost in a 7-0 majority. We very rarely get a judgment where no judge, none of the members of the bench dissented in any respect. As I've mentioned in the previous video, therefore, this is one of my favorite landmark judgments, not because what was held or not, that is immaterial. We are basically analyzing the history of the Supreme Court, and this is my favorite judgment because absolutely all of them, 7 different judges coming from very distinct, disparate backgrounds, all of them found in favor of the fundamental rights. All of them insisted that fundamental rights override directive principles. Directive principles are not enforceable, and that is why this makes to be one of the shortest of the landmark judgments ever given by the Supreme Court. It's a very short judgment, just 3 pages. I know a couple of people who know the judgment by heart. It is that concise. But the consequences were not concise. The consequences were extensive. In fact, even before the judgment was given in April, a month before that, while the court was hearing these arguments, the law ministry had already written to the cabinet as a whole recommending the amendment of the constitution to protect provisions and measures such as the communal GO, under which reservations to government medical and engineering colleges in the state of Madras had been provided for. So extensive consequences, massive ramifications, which we will discuss when we start making videos about the First Amendment. We have already touched upon this in the Romesh Thapar and Brij Bhushan cases. They also contributed to the First Amendment, as did the Champakam Dorairajan case, and there were of course other judgments not made by the Supreme Court but by various high courts regarding the right to property. All of them contributed to the 3-pronged amendment of the Constitution, the First Amendment to our Constitution, and so we will look at that in future videos. Hope you have found this one instructive, and I hope you will join us when we make our next video. See you then. Thanks a lot for listening. Bye bye.